You're an indie game developer and you've been working on your game for years. Original story, hand-drawn assets, custom sound design. You release it online. You get some traction and you're proud. Now fast forward 6 months. Someone shows you a trailer for a new AI-generated game and you see the same visual style, same narrative beats, same emotional arc, but it's not yours. It's been remixed, synthesized, generated. You didn't license your work, you didn't give it permission, but it happened anyway. And when you try to prove it's yours, the trail goes cold. You have no timestamps, no registration, just your word against the machine and the huge company behind it. This is the reality for game developers in 2025. Your work is being scraped and scalped into AI training data. Your mechanics are being analyzed, your art is being synthesized, and most developers don't know what they actually own or even how to protect it. This is not an episode framing AI as something to fear. In fact, in part 2, we speak to the people using AI and how to ensure that they don't run into any problems with their new creations. Instead, it's about understanding how to build the strongest fortress around your creations, however they're made.
Welcome to AIX Gaming, presented by the Rift Fitters Network.
Today we're breaking down how to build a fortress around your creations, what's really yours, how to prove it, and how to defend it in this AI era. I'm Chris, and this is AI Gaming on the Rift Fitters Network, bringing you part 1 of building a fortress around your game and assets in the age of AI. So here's what we're covering today. First, we'll decode what you actually own as a game developer. Spoiler, it's probably a little bit less than you think. Then we'll dig into the messy reality of ownership. Do you really hold the keys to your game, or did you accidentally sign them away? After that, we're confronting the AI threat heads on. Your work is already being scraped, and we'll talk about what that means legally and practically for you. Then comes the action part. I'm walking you through copyright registration step by step. Think of it as your legal power-up. And finally, we'll explore the layered defense strategies, trademarks, trade secrets, patents, the full armor. By the end of this episode, you'll have a clear roadmap to protect your work. Not just from AI, but from anybody who might try to claim what's yours. Let's build that fortress. Part 1. What you actually own. Game developers are creative polymaths. You write code, you design levels, you compose music, you craft narratives, you build mechanics, and you create worlds. But here's the thing, not all of that is legally protected in the same way. Let's break it down. Your code, that's protected as a literary work under copyright law. That's correct, literary. Your scripts, your functions, your elegantly crafted algorithms, they're treated like prose. If someone copies your code line by line, that's infringement. Your art assets, they're also covered. That includes sprites, textures, 3D models, animations, they're all protected. Your audio is the same deal. Music, sound effects, and voice acting are protected. The narrative, however, the actual text, dialogue, story beats you wrote down, also protected. But here's where it gets a little bit tricky. Your game mechanics are not protected. Let me say that again. The rules of your game, the systems, the way your platformer handles double jumps or how your card game balances risk and reward, that's not covered by copyright. Think about it like this. You can copyright a recipe's written instructions, but you can't copyright the idea of combining chocolate and peanut butter. That's just a method or a process. Game mechanics are the same. You can't own the concept of a battle royale, for example, shrinking circle or stamina-based combat systems. Those are ideas, and ideas aren't protectable. That matters because AI is really good at replicating the unprotectable things, and an AI study can find your game's rhythm, your pacing, your balance. It can learn the feel of your mechanics without even touching your actual code or the art. It's like someone watching you cook and then making the same dish without ever looking at the recipe card. And this is the very defense that is doing most of the heavy lifting in the legal cases facing a number of AI companies today that are caught doing the scraping. So when we talk about protecting your work from AI, we're really talking about protecting the parts that are copyrightable. Your expression, your execution, not your ideas. And that's a narrower window that most developers realize. Part 2, do you even really own it? Okay, so you've created your game, you wrote the code, you drew the art, you composed the music. It's all yours, right? Maybe, maybe not. Let's talk about ownership because this is where the things get messy fast. If you're a solo developer working on your own time with your own resources, you're probably fine, you own it. But the moment you add another person into the mix, things get more complicated. Collaborators. You brought on a friend to do sound design. Another person handled making character sprites. In the eyes of the law, you might now have joint authors. Joint authorship means everyone owns an equal share unless you have an agreement saying otherwise. That sound designer, they could theoretically license the game's audio to someone else without asking you. They could even create derivative works, not because they're malicious necessarily, but because that's how joint ownership works by default. The fix for this is work for hire agreements or assignment agreements. You got to get it in writing. Make sure the contract explicitly states that you own the work product and not them. Before they start, not after. Now let's talk about your day jobs. If you work at a studio otherwise and you're doing independent development on the side and you go home at night and work on your indie game, it's a totally separate project, right? Not necessarily. Most employment contracts have an intellectual property clause. A lot of them are very broad, and they say things like any work created during your employment using company resources or related to the company business belongs to the company. Some are even more aggressive. Any work created during employment, period, is owned by the company. That means your indie game technically could be owned by your employer, even if it has nothing to do with your day job, even if you used your own computer. So there exist developers who have had to go back and get written exemptions from their employers just to make sure their side projects are actually theirs. It's a little bit uncomfortable, but it's very necessary. Then you have third-party assets, a texture pack that you bought on Unity Asset Store, a font from Google Fonts. You pulled in some open source code from GitHub. Do you own those? You don't. You have a license, and licenses have terms. Some are permissive. You can use it however you want. Others a little bit more restrictive, that you can use this but only for non-commercial projects, or you must credit the author. Or any derivative work must also be open source. If you violate those terms, you're infringing, and if your game gets scraped into an AI model, you might not even be able to enforce your rights because you don't fully own all of the components. Here's the takeaway. You can't protect your work from AI until you actually own every part of your work. Clean title, clean contracts, no ambiguity. If you're not sure, audit your game right now. Every asset, every collaborator, every license, make sure it's all yours. Part 3. Let's talk about what's actually happening with AI and your work. Your game is already in the training data, probably. AI companies are scraping everything. GitHub repositories, itch.io uploads, public game forums, YouTube playthroughs, Discord servers. Anywhere you can publicly access material, it's being fed into the models. And the thing about it is that a lot of it is happening in a currently legal gray zone. AI companies are arguing that training on publicly available data is fair use. Fair use is a legal doctrine that allows limited use of copyrighted material without permission for purposes such as research, education, or commentary. They say training an AI model is transformative. It's not copying your game, it's learning patterns from millions of works and creating something new. You might say that's nonsense, that it's still using your own work without permission. And you would have a point. This is being fought out in court right now. Artists, writers, and developers are suing AI companies, and outcomes of these cases will shape the industry for decades to come. But here's the reality. Even if those lawsuits succeed, even if the law shifts in favor of creators, you still need to prove your work is yours. You need documentation. You need evidence. You need legal standing. And that's where copyright registration comes in. In the US, you automatically have a copyright the moment you create something. You might have heard that. But automatic copyright is weak. You can't sue for infringement without registering first. You can't claim statutory damages or attorney's fees without registration. It's like owning a car but not having the title. Sure, it's yours, but trying to prove it in court becomes a much more complex battle. Registration is your proof, it's your timestamp, it's your claim in the public record. And in an era where AI can replicate, remix, and resynthesize your work in seconds, proof is power. So if you take one thing from this episode, let it be this. Register everything you can. Your code, your art, your music, your builds. Do it now, because once your art is out in the wild, it's already being scraped and the clock is ticking. Part 4, we're going to take you through a step-by-step copyright registration process. We're going to get tactical. You're ready to register your game. Here's how it actually works. So first, what exactly are you registering? You're registering the creative expression of your game, the code, the art, the audio, the text, and you can bundle all those together under one registration as one single work, or you can register components separately if they're published separately. For most indie developers, a single registration for the game is going to make the most sense. It covers the compiled work and the player's experience. Now, where do you file? If you're in the US, you go to copyright.gov. You're going to create an account and click Register a Work. For a game, you'll need to choose the category that best fits what you want to protect. Most developers are going to choose Computer Program, since that covers the game's code and functionality. If you want to protect the creative elements like the story, the art, the music, or some cutscenes, you can also register those separately under Work of the Performing Arts. Many game devs file both to fully cover their work, and more documentation is usually recommended. So next you'll fill out the form. Put in the title of the work, your author name, your year of creation, your year of publication, if it's been released, and if it's been using work for hire. It's pretty straightforward. Then comes the deposit. The Copyright Office wants to see the actual piece of work. So for a video game, you're typically going to upload gameplay footage. Screen recordings can show the game in action as well, or 5 to 10 minutes is usually sufficient to show the interface, the mechanics, the story, and give them a sense of what's making your game unique. But again, more might be better. If you're registering the code specifically because you have some very specific mechanics, you'll upload the source code files as well. Usually the first 25 and the last 25 pages of the code base are going to do well. If it's less than 50 pages, you're going to submit the entire code. A pro tip is to redact any trade secrets before uploading it to the Copyright Office and making public deposits, because anybody can access them. So if you've got proprietary algorithms, you don't want them exposed, black them out. Next is the fee. As of 2025, the cost is $65 for a single online registration. This kind would be like a game with multiple contributions or complex materials. But it's only $45 if you're registering a single work by a single author. So it's not too expensive, and the value it provides is enormous. Submit everything. The Copyright Office will review it with processing times varying with anywhere from a few months to a year depending on the backlog. But the good news is that the registration is backdated to the date you filed. So even if it takes 6 months to process, your protection starts the day you submitted the application, so do it as soon as you can. Once you're registered, you'll receive a certificate, a literal piece of paper, or a PDF that says this work is registered with the U.S. Copyright Office, which is nice and fancy. That certificate is your legal superpower. With registration, you can now sue for infringement in federal court. Without it, you can't even file the lawsuit. You can claim statutory damages now, which can range from $750 to $30,000 per infringement, or up to $150,000 if the infringement was willful and intentional. You can also recover an attorney's fees, which makes it way easier to find a lawyer willing to take your case. Without registration, you're limited to actual damages, which means you have to prove exactly how much money you lost, and that's really hard to do. Lawyers are also less likely to take on the case because there's less financial upside for them and security. So registration isn't just paperwork, it's a power-up for you. And in an industry where AI is scraping everything and everyone's to move fast and break things, you need every advantage you can get. Here's your action item. Before you release your next game, register it. Before you push your code to GitHub, register it. Before you post your art on social media, consider registering it. Make it a habit, make it part of your launch checklist. Right between test for bugs and post on Twitter. Because once it's out there, it's being used, and you want proof that it's yours. Part 5, your layered defense system. Copyright is your foundation, but it's not the only tool in your arsenal. Let's talk about the layered defense. Trademarks. Our copyrights protect your creative work, but trademarks will protect your brand identity, your game's name, your logo, your studio name. So if somebody releases a game called Fortress Mode and your game is called Fortress Mode, trademark law gives you some recourse. Even if their game is totally different, if it causes confusion in the marketplace, you can stop them. Trademarks are registered with the USPTO, not the Copyright Office, so they're totally different processes and they serve a different purpose, but just as important if you're building a brand around your games. Trade secrets. Some things you don't want to register because registration means disclosure, and disclosure means it's public. So if you've got a proprietary algorithm, a unique back-end system, or a secret sauce that makes your game special, consider keeping it as a trade secret. Patents. Patents can be tricky for game developers. They're expensive, time-consuming, and most game mechanics don't qualify. But if you invented something truly novel, a technical innovation, a new method of procedural generation, or a unique network architecture, a patent might be worth exploring. Patents protect processes and inventions, not creative expressions, so they're a different beast entirely. Most indie devs won't pursue patents, but it's worth knowing that they exist. You don't need all of them for every situation, but knowing what's available means you can suit up appropriately. So in closing, where does this leave us? Game development in 2025 is a battlefield. AI is scraping everything. Legal frameworks are evolving, and if you're not proactive, your work will be used without your knowledge or even your consent. But you're not powerless. You can own your work. You can document your process. You can register creations, and you can layer your defense systems. Think of it as building a fortress, and documentation is your moat. So where does this leave us? Game development in 2025 is a battlefield. AI is scraping everything, legal frameworks are evolving, and if you're not proactive, and your work will be used without your knowledge or consent. But you're not powerless. You can own your own work. You can document your own process, and you can register your creations. You can layer your defense system. Think of it as building a fortress, and documentation is your moat. Keep a development journal. Screenshot your progress. Save your build files. Archive your commits. If you ever need to prove you created something first, you'll have the evidence. Contracts matter. Get them in writing. Every collaborator, every freelancer, every third-party asset. Make sure you own what you think you own. And register. Seriously, it's $65 in an hour of your time. There's no excuse not to do it. AI isn't going away. It's going to get better at replicating styles, mechanics, and experiences, and legal battles are just beginning. But I promise if you build your fortress now, you'll be ready. You'll have the tools to defend your work, you'll have the legal standing to fight back, and you'll have the peace of mind that comes with knowing you did everything you could to protect what's yours. Next week we'll be flipping the script. We're talking about how to use AI in your development process without losing ownership, how to prompt, train, and integrate AI tools while keeping your IP intact. Because this isn't just about defense, it's about evolving. Until then, I leave you with one question I'd love if you could answer in the comments. Do you guys think copyright law is equipped to handle the AI era? Or do we need an entirely new framework for protecting creative work in the age of machine learning? Leave your thoughts in the comments. Please follow and subscribe for more content that helps walk artists like you through ever-changing landscapes that is AI and technology. Thanks for watching AIX Gaming. We'll see you on part 2.
That was AIX Gaming, presented by the Riftfitters Network. Thank you for listening, and please, remember to subscribe for weekly updates keeping gaming industry creators like you informed in the new era. See you next week!